And then we have two folks who are new to this panel, and I would let them introduce themselves.
Thank you, Bob. Richie Prager, BlackRock.
Jim Harshaw, GM Pension.
So we're now going to talk about the advantages and disadvantages of the different models, and most importantly, the advantages and disadvantages of the models compared to each other. And so one of the things that was sort of alluded to earlier, and I'd like to raise it here now, is what are the differences, if any, between swaps and that industry and the both cleared and uncleared, and the futures markets that are relevant to this discussion?
Start, Bob? I mean, I think we heard some of it in the prior panel, and I think it's a great question to start with to sort of frame just some broad differences. So when we look at the OTC market and the swap market and look at some of the statistics published by ISDA, my understanding is some 600 trillion notional outstanding. We have today, I think in the cleared space, some 200 trillion of which is cleared primarily on LCH in a dealer-to-dealer environment. So that's one metric. I think if you look at the another metric, you look at tenor. I think most dealer books outstanding average life would probably be somewhere 3 to 4 years. You look at LCH, my understanding there is their average life of their cleared population is some 8 years of tenor. So if you start thinking about the variation margin in the context of 8-year average life, that's something to consider. Then if you look at CME and some of your figures, and I'm sure they'll both help me here if I get their figures very, very wrong, but I think in CME's interest rate complex, just thinking of Eurodollars, T-notes, Fed funds, there's some current open interest of some 15 trillion or so, and if you take Fed funds out of that, it's about 11 trillion size market. So a very different size if we're talking about. Then if you look at the tenor, most futures are fairly short-dated in maturity. So we're looking at, just think of sort of rolling Eurodollar futures with huge volumes. Most of the volume is in the front contracts, and they mature every 3 months. So the variation margin over the life of 3 months is going to be very different over the variation margin of something that's 8 years. So I think when it's a great benchmarking question to start with, because we start talking about these different models and we defer to, we say we defer to the futures model. In a lot of these conversations, these are apples to oranges when we start talking about risk. So, that would be my cut at the broad differences.
Can I ask a question, though, Richie? You're making it sound as if there's a difference in the way the risk posed by the variation margin if something exists for a long period of time or if it exists for a shorter period of time. And with the variation margin being settled every day, I'm not sure I understand the distinction.
Well, I'm just looking over the life. I think that's a fair point, Kim. I mean, I think, first of all, these sheer volumes. I mean, we're talking very, very different size markets. And if you're, a lot of these futures that we're talking about, the futures market, are very short-dated contracts anyway. So if you look at the daily variation margin of something that has 3 months of duration and, a very small BPV versus an average life contract of 8 years, so a daily, just the daily variation margin alone and the sheer size and the longer duration with a higher BPV, just much larger numbers.
I think, Richard, I would add to that. I mean, I agree with your comments already, but I would add to that also the difference in terms of how the products trade, in the sense that a lot of the swaps basically reside in a book for a long time after the initial trade. So it's about the unwind. The unwind aspect of the book is going to be different versus a shorter dated, 3-month future, basically, which is eminently observable. So it requires a longer unwind horizon, and it has to be handled with more care, I guess.
And also the operational needs of margining and doing the computational calculation every day is different on the OTC products. They have longer dated cash flows, they have coupon resets, things like that. So from doing the portfolio calculation every night, which both the FCM and the CCP need to do, it is a more computationally complex instrument.
Also more model-based. Valuation is more model-based. While we build an interest rate curve, all the off-the-runs or anything that's not traded that day is discounted and so on. So there's a model valuation that's separate from a widget price that trades in a central order book. There is no central order book for the swaps.
So it seems that the comments you're making go towards differences in how they could be cleared.
Yeah, right. And also the variation margin is collateral.
Right.
Which is a rather substantial difference from the futures clearing model where variation margin is daily settlement.
So you're saying that VM is collateral and you don't call it, what is IM then in a OTC trade?
Also collateral, but the VM collateralizes current exposure.
Yeah.
And IM collateralizes potential future exposure is the way we think about it.
I think one of the things that's important to understand is that in the OTC area, in the OTC area, for most of the people on this side of the panel, on the buy side, they don't post what you call in the futures area initial margin, but in the swap area is called independent amount. And so out of the box, when you go to the cleared side, it's an economic negative. Second, the models exist today, the futures model, the swaps model. Over 90% of global derivatives are done in the OTC swaps market as compared to the exchanges. And people have chose that for a reason. There's a lot more flexibility in the OTC area to establish the types of protections that you want to have with your counterparty. How much you want to be exposed to the risk, how little you want to be exposed to the risk. When it comes to the margin that you post in the futures area, they really don't have much choice. In the OTC area, you can negotiate that, and in addition, you can actually control it, and that has important portfolio management consequences. If I'm holding a bond and I've got a tri-party, that bond is still mine. It's pledged for the benefit of a secured party, but it's still in my portfolio, and I'm getting the income on that bond. And when you look at my assets list, it's going to have that bond. In a futures area, I give up a bond to the FCM. Well, that bond Treasury could get converted to a Greece bond the next day. I don't have the Treasury in my portfolio anymore. And so there are significant differences between the futures and the swaps market, and today the buy side opts for the swaps market model.
And let me try and focus folks a little bit, though, on the distinctions, to the extent there are any, between swaps as they might be cleared and futures. Because one of the points that folks have raised is, wait a minute, we've got a futures model. It works. It's worked for a very, very long time. And so we should then bring swaps into this model that has proven itself. And I guess the question is, are there, in fact, any differences that would challenge that? Or, in fact, is a cleared swap really the same as a cleared future? And maybe that argument has weight.
I think one of the things that we need to pop pretty quickly is the 100-year example. In '87, when the market crashed, the CME, as I understand from people who served on the risk committee during that time, went to get margin from the FCMs, and many of them couldn't post it because they couldn't get it from their banks. And when margin is called, it's called on a T+1 basis from the customer, and on the CME, as we understand it, it could get called that day. We understand that there was pressure put at the government to force the banks to lend to the FCMs. Had they not gotten the capital, we may not be bragging about CCPs today. In fact, one of the CCPs in Hong Kong went under. So, we're talking about a structure that hasn't been tested. It's a bicycle compared to the OTC car, and it's carried the weight of that person, but now you're taking, tons of bodies and trying to put it on the bicycle, and it can't bear it. And what we're saying is that the risk assessments of the CCP need to be rethought in light of the volume.
Can I just maybe come back on that? Because it has been tested. We've cleared interest rate swaps as traded in the OTC market, no change to the way they're executed. Richard gave some statistics just to correct him a little bit. We have over 50% of the open notional going through swap clear today. And when Lehman Brothers defaulted, that was a $9 trillion portfolio of interest rate swaps, idiosyncratic, no trade the same, so therefore no profile of risk on each trade the same, so non-standard. There were 66,000 trades. They were out to a maximum maturity of 30 years. They were in 5 different currencies, and we closed all that risk out using in the region of 100, 150 hedge trades in the market, big trades, macro hedges, and then auctioned the portfolio and gave that back to the market. So that was all done well within the margin that we had of Lehman, so nobody was impacted in a mutualized way. Obviously, this is very much dealer-to-dealer centric back then, and we're expanding that model out now to dealer-to-client. But to say these infrastructures haven't been tested is not 100% true. I know Kim mentioned in one of the earlier sessions, one of the reasons we're moving this model into this model is because of the success of the futures model. I'd like to think as well it's maybe something to do with the success of closing out a large OTC derivative portfolio of Lehman as well. So if you take a slice through our portfolio, which it's cleared swaps, we've got about 910,000 trades. When we did a slice through of about 850,000 trades that we had, more than 95% of those trades, if using 8 fields to match, were different. So every single trade is pretty much different that you clear today. So I think that's a fundamental difference between swaps, to answer your question, of swaps and futures. They're not standard, they are different, and they are idiosyncratic. So I think we have to be very cognizant that you can take a swap product, an OTC product, and clear it. But to Jim's point, the risk profile on these, the maturity profile, the way you hedge these is very different to futures. But I'm sure everybody will agree on the DCO side. The risk principles we apply should be the same. It's just maybe the metrics and the models should be slightly different.
And I would agree with the statements about the way that the model has worked and the way that it's been tested. The fact that the Fed flooded the market with liquidity in the crash of '87 is going to have been a fact whether or not there were futures or not. And all of the settlements were met at the CME. There was not a failure by any participant at that time. So, that was a test. I think the credit crisis period was a test, certainly on the Lehman side in London where there actually was a default. But I would suggest even on the Lehman side in the U.S. where there was, because of the difference in the bankruptcy structure, the registered entity didn't actually default, but it did operate in a state where it had an impaired parent, and I think that the mechanisms that were in place operated very well to be able to allow customers to manage to a very good outcome in a very stressful time period.
I'd like to sort of repeat the question, but maybe in a little bit more focused way of taking some of the observations that people have made about differences with swaps, and again, taking as a given that we're talking about the subset of swaps that are going to be cleared in the future, and then focus especially on whether these different, or how, if at all, these differences would affect fellow customer risk. Even if there's a greater volume on a transaction-by-transaction basis, is the fellow customer risk and managing it either from the DCO or customer kind of way going to be the same, or do some of the differences that Dan, for example, has talked about affect this?
I think one of the things on the fellow customer risk is it's just not something we have to deal with today. And, so again, you have the untested aspect to it. On the sell side, has a lot more experience on the clearing side. There's been very little cleared by buy side. And so the experience that maybe other people have had and had tested on hasn't really been so on the buy side. We're really not set up to measure the credit aspects of any other customer, let alone all the customers of an FCM. Frankly, we don't feel we have enough tools to measure the risk of our FCM. We don't feel the DCOs have enough tools to measure the risk of the FCM. We think capital is a specious test because you could be levered out the wazoo and have a lot of capital, and we certainly seen that to be the case. We think leverage is hugely important. AIG was highly rated, but highly levered, and none of us knew that. So I think for us, the fellow customer risk just underscores the fact that the buy side just doesn't have the tools or the information to evaluate it.
If I can add on to that, I think this is a key point. And so if you look at both fellow customers and FCM, so we talk about Lehman and the very successful experiences both the CME had with futures and LCH had in cleared swaps. There's not every situation we're going to have CNBC talking to us for weeks in advance, basically saying, move your exposure. That was a unique situation where basically there was a neon sign flashing 24 hours a day saying, you may want to think of moving your exposure. So I don't think we can count on that unless the DCOs themselves are going to establish that neon sign and somehow rate the FCMs and somehow put out a yellow warning or red warning or whatever, because we don't know. We can make our own initial assessment on the health of the FCM, and we do. And we look at capital, we look at other metrics, but it's largely judgmental with not a lot of objective measures in terms of their ability to select clients, their ability to comply with DCO rules. We don't know if you publish, the ratings. It'd be great if there was some sort of rating system. I don't know, I go into a deli in New York and I see this little score there, whether I should buy a sandwich or not. Then on the fellow customer risk, no idea. They're clueless. We are then back to looking at the FCM and the DCO to provide guidance. So we have no idea if there's an amaranth in there, if there's other types of clients, and we have no idea they may be in every FCM. And this is an area of great concern. Where I think that's a risk that we just do not take today in the bilateral swap world. We do not have to worry about it. It's just we can insulate ourselves from it. Full stop. So I do think this is a very key component, and we wrote that in our comment letter that we'd like to see something coming from the DCOs on how they monitor the FCMs and how they and what guidance they can provide clients with.
Well, I think
oh, go ahead.
I was going to say, Richie, I think it's a little bit bigger than any one DCO. There's common membership across all three of us and some entities and other entities, different levels of that. At some point in time, that may need to be a regulator function that's providing that. Your deli analogy, it's not the individual block association that's putting up that sign that says this deli's good. It's the health department in the city of New York. We would like to see that too. Membership and offering new products and soliciting the right group of people to provide that service and the right level of distribution out to customers like yourselves. We also need that type of help, and that's going to require some effort, from this agency and other agencies. And if we think about the holistic view of that, when some of the clearing members are registered banks, or the likelihood that some of them will be or have some affiliate structure with that, and the rules around that, we also need to know what that means on the other side, and what those regulators are thinking. And there's no good place to go to. So even though I could give you an A rating on, FCMA, they may not have A ratings at the other two places, and vice versa. There is no single place to put that, and it's a risk I think we all face in the industry, not just your side of the fence.
I agree with that. You have fellow customer risk, we have fellow CCP risk, I guess. We need to know what the leverage is, the capital is, the risk that they're leveraging and how it's being used, what the liquidity aspect would be on the capital that they've got. We can't see that. We can see what we can see, but we can't see it across the piece. So it's a similar issue that I think the buy side are raising. But in terms of differences between futures and swaps, with reference to the account structure, is a blend of things. Obviously, the swap product, the OTC product, is longer dated. We could argue all day, but one would argue that longer dated probably has slightly more volatility in price. We could argue about that, but equally, one thing I think we wouldn't argue about is liquidity. And the further out the term structure you go, the further out the maturity profile you go, the less deep the market is, the less liquid the market is. So what does all that mean? It means that in the worst case scenario where we have a default, it's going to be hard to close out that risk. If it's going to be hard to close out that risk, the last thing we want to do is have to close out more than the defaulting entity. In terms of collateral segregation, like an LSOC or a full seg model for that matter, so just a segregated model, we have pretty good confidence because we can see the client ID, we can see through to the end client, and we can apportion the collateral in that model. We can safely lift those people and move them to a safe clearing member at that point. So as a DCO, we don't feel necessarily that we're going to have to close out additional risk for somebody who they've not defaulted, they just can't port. And the reason they can't port necessarily is because in today's structure, in the Omni account, we're not going to let people port unless we are confident that we're not going to have to use that client mutualization layer. Whereas under an LSOC model, we can say you can go as fast as you can go rather than as fast as the slowest person.
And just to clarify, so what I'm trying to understand, Dan, is what you're saying there's a difference in liquidity generally between cleared swaps and cleared futures?
I'm saying there's a liquidity difference, and it's harder to close out longer dated risk on swaps than it would be on a standard futures contract where you trade in and out.
It's not so much, it's that the risk is so much bigger. And there's no central order book to put it anyway, but the risk is so much bigger.
I think the biggest difference between the futures and the swaps, first of all, traditionally futures trade in a silo environment. You will see one risk being in one location. Here we will have, most likely we're going to have the same instrument traded at least two CCPs. It's going to make it more difficult for them to actually see for the same shock what is going to be the behavior of the client, how much is the certain client affected. They know that they have exposure to 1 billion of CDS of an index in CME, but there might be another 1 billion in ICE. They don't know what the impact is going to be. I think when it comes to health, when it comes to assessing the health of the clearing members, the FCMs, I agree with Chris that they don't have the tools to actually do that themselves. At some point, I think we're going to need the regulators to be able to try to conduct some kind of stress test for the existing FCMs to actually assess the health of those FCMs for general shocks in the market.
I think there's a different, I would draw a distinction, I think, between the ability to manage risk at the CCP level or at the regulator level and the ability or efficacy of putting out a rating. I think we all found that the rating services sure put out ratings, but they weren't necessarily as helpful as they might have been relied upon to be. But as far as the risk management, I mean, we do our risk management and in the listed business, and we're set up to do it in the over-the-counter business at the individual customer level. Now, in the futures world, you can't see every customer. You can only see the ones that have 25 contracts or more. So you can only see the ones that are even in, by anybody's definition, marginally material. If you have any kind of a presence in the market, we can see you. We can evaluate the concentration risk that the clearing members have among their customer base, and the CFTC, as a central reporting mechanism, sees that across all of the markets, and I presume we'll see that across all the cleared and probably even the uncleared swaps because of the SDR and the reporting functions that will be in place. So I think there will be an ability for there to be risk management that is performed at that includes each CCP doing it from their own viewpoint, and then the regulator being in a position to do risk management at the overall.
Who is the we you're talking about? Because you're not going to be able to see the unclear transactions that someone else will have. Only the regulator will have access to that.
Right.
Okay.
We each can see our own piece, the DCOs, and the regulator can see the whole picture.
Before we move on to risk management, and we will, I just wanted to wrap up one point I'm trying to understand here. So what I'm hearing is there is greater risk because of perhaps either longer structure, lesser liquidity on the swaps end than the futures end. And I guess the question is, what would the impact of those distinctions be for fellow customer risk?
mean, I think one of the things you're hearing that there's more risk, but you didn't also mention that there's different risk management that attaches to some of those risks. Those products are margined differently from the way that the simpler structures are margined, and the default management practices that each of us has in place to facilitate the liquidation of the less liquid, less visibly liquid product sets are very different. So
that default management would be post-default,
and it's managed differently as well.
Bob, I think one of the key points here to understand is that when you're talking about collateral, we have transparency right now. So in a tri-party arrangement, there's a third-party record keeper independent of the FCM who gives transparency on the collateral that's been posted by the FCM or the collateral posted by us, our swap dealer, or the collateral posted by us for the benefit of the swap dealer. In the DCO world, what we understand, and I'm glad to stand corrected, is that although the DCOs, and they vary among them in terms of what they can see at the customer level, although they can see margin exposure, they don't see collateral. And so they don't get to see, what I posted to the FCM. They get to see my margin exposure for my contracts, but the DCOs don't have transparency into the collateral. And so there's a key protection that we've got in the OTC area that doesn't really exist in the CCP area, and that is the transparency on the collateral.
Well, let's focus on that.
And on a day-to-day basis, we don't see the collateral that's in the account of a customer at an FCM, but we do have transparency into the efficacy of the practices of holding margin and holding it in segregated accounts through the financial supervision and audit functions. So there is ongoing monitoring of that, but it isn't a day-by-day view into the balance in the account at any point.
It's a periodic versus a daily reporting that we can get from a third-party bank.
Just to be clear, as I'm understanding what you're saying, Kim, you of course know what they've posted with you.
I know what the FCM has posted to me, and if we live in the LSAC world, I will know. I won't know anything different in an LSAC world than what I know now, because right now I'm margining each account individually. The FCM has enough margin up, so if you allocate it across all the requirements, everybody's got enough margin up, and that's exactly the same thing that I will know in the LSAC model. I won't know that it's actually James's collateral, though.
Right? No, you don't know whose it is, but in other words, you know what you have. Secondly, as I'm understanding it, and I understood this way before, but I want to make, this is what I'm hearing you say now as well, you supervise your members. You don't know every day what they've collected from customers, but on a periodic basis you look and you see what they've collected, and you evaluate then if they are undertaking from your perspective appropriate risk management.
That's correct.
Well, just distinction between full seg and LSOC. On the full seg, we will not have, if James does a trade or a bunch of trades via an FCM and the margin on those trades is 100, the DCO will not register or clear those trades unless they've got 100 from the FCM. So we will always see that we have 100 against those trades, and if there's somebody else, William next to him has done 100, we'll see 100 as well, and we'll have 200 in the account. So we will always see the collateral value. The distinction here is that we won't see that James gave the FCM some T-bills and William gave the FCM corporate bonds and did some transformation and passed them through. But we will always see the collateral value of relative to their risk. We will always have that reconciled in the clearinghouse, certainly in the LCH model. The others speak for themselves.
That would be true in any model that we would have collateral.
I mean, even in the case that we have today at ICE Trust, where we take gross margin on behalf of clients' trades, and if a clearing member today charges additional margin, or we'll call it excess, so if the clearinghouse is calling, in Dan's example, $100 for that given position, and the clearing member says we need $120 to support that position for whatever the reason and whatever risk management they've decided to put on the customer account, we're collecting all 120 in that. Well, at least 120 is being paid, but to Dan's point, the composition of that 120 and what you may be giving to your clearing member, there's no visibility in that. All we know is that we needed we needed 100. 120 was collected. We're taking that 120, and we're segregating that off and putting that out of harm's way.
So, as I understand it, on a day-to-day basis, you don't have that visibility. Do you have the ability to look at your members on a periodic basis to determine the the quality of the risk management that they have?
We certainly monitor their behavior on a daily basis, and I would say that there are periodic reviews, and certainly, there are times where operational issues around their risk management capabilities are discussed at appropriate levels within the governance structure in our entity. So,
I guess my question would be, did that help in the Lehman situation? Because, the reality is that you can have that periodic oversight, but it didn't stop anybody from allowing Lehman to continue to clear.
How much,
maybe just
on
come
that
back on
score,
that.
how much did you folks lose in Lehman?
0.
One of the things that we're talking about here is what happens with my collateral and what's the risk associated with that. I think we'd all agree that this room can accommodate a certain number of people, and we're all comfortable with that. But as the numbers get bigger, our comfortability goes down. As we talked about at the beginning, the volume that these platforms have had before, all significant in certain cases, has certainly not been the $600 trillion. When I post collateral today, I get to see it, and I get to walk through its transit. That transit risk doesn't get protected, it doesn't get covered in the LSOC. It doesn't get covered in the futures model. And so when variation margin comes back and forth, it gets passed around, and there's risk in transit. One of the advantages to the tri-party arrangement, and as was suggested this morning, perhaps adding the DCO to that, is that you don't have that transit risk. And so in a bankruptcy where there's tons of players, much more than we've ever had before, on the clearing experience that people were talking about and praising, and that there was 0, there were very few players on those markets because it was just the dealers. Now we're talking about adding the whole market. And so, albeit it's comfort. Is it complete comfort? Absolutely not. And we would say when we went through Lehman, we had tens of millions of dollars exposure to Lehman. Guess what? We got it because it was in our accounts with the bank, and it protected us. And what we're saying is, if you're asking me to get out of a car with airbags, seat belts, side bags, and get into a car without that, I'd say I should have a right to wait until it has it. And so we're suggesting that the optionality model here would address these very collateral and these transit risk and these other risks, and we should just wait till we get that taken care of.
I think, one of and I mentioned this towards the end of the last session, I think one of the things that would make the buy side feel more comfortable is greater insight and greater disclosure into the FCMs, as this gentleman at the end of the table said. And it's something that we suggested in a comment letter that we wrote some time ago on this topic, greater disclosure. And I don't think that, well, I speak for our firm, but I don't believe that many FCMs would have an issue with that.
Well, let me ask about that, because I assume what you're talking about certainly is things about information on your balance sheet.
Well, yeah. What I was thinking is I'd be very interested to hear from this group what information they would find useful, or what they would think would be material information that they're not getting right now.
Well, let me ask this: would the information that you're willing to disclose also include the policies that you have for doing risk management?
Would think so.
And would that also include the exceptions to those policies?
I don't know. I mean, I haven't really considered that. But again, I'd rather hear from this crowd what.
Well, I'll take a shot at that. I think if given the choice between more transparency around our FCM and their policies, and it would have to go beyond that, because we'd have to have transparency into who else is in the client pool if we're using the omnibus method. if I had the choice of that versus a full segregation model that would give the certainty around the collateral, I'd choose the latter. Because the former, while it would give you some comfort, the world's a very dynamic place, and those exposures, those financials, those counterparties can change from one day to the next. And I think many of us, you've heard, if there's a common theme, we'd really like to have control over our own destiny. That's what we've had in the OTC market. We've been able to choose our OTC counterparties. We've been able to isolate our risk. If we choose one counterparty and not another, we know we have no exposure to that counterparty. However, in an omnibus model, we could be exposed to that counterparty in the omnibus pool. So we lose control over our own destiny. And again, I'm sorry to come back to this again, but if we're not given a choice, what we will choose to do in a market that is disrupted, we will back away. We'll pull our capital away, and that will add to the diminishing liquidity in the marketplace that will already be there as a result of the crisis itself.
Yeah, if I could add, and I completely agree with John. If given the two choices, I'd rather not have to make those judgmental calls based on ratings and judgments of those fellow customers. And, as a fiduciary, we would like not to have to make those type of risks. We are hired to make investment risks. If we could standardize this by having, the segregation and take that decision-making away, and then we can focus on, our expertise. That's what we're hired to do. And, so if maybe you're where we end up is forcing more disclosure with FCMs, and then we're going to just have to hire ourselves more credit people to can make those assessments. And we will be forcing you, John, to tell us every time you have an infraction. And we want to know when you have, whatever, the regulators do to sanction you. We will expect that to be disclosed, and we'll want to know all those customers. And that's, we're going down, that sounds to me like going down a path which is unnecessary given the options on the table. And the proposed rule just, negates the need to do all that.
Just to be clear, if you were to do that, would that impose any costs on you?
Absolutely. That's what I said. We'd have to hire all sorts of risk management people. We'd have to be going out doing the same sort of, diligence. Kim was talking before, about soaring audit costs. We'd have to hire whole departments, go out to interview FCMs, monitor change every time there's any change in their balance sheet, look at different customer profiles. I mean, it's just a whole different nature of risk that today we don't have. As you've heard down the aisle here in the bilateral world, we have people that make it's a limited number of counterparties, but we don't have this notion of fellow customer. That's this unknown to us.
I'm not sure I guess I completely agree with that, because even when you're dealing with a dealer, I mean, that dealer has multiple products, multiple activities, multiple customers. You don't know on the other side of your activity what it's doing necessarily.
But if we're in a tri-party, it's not an issue.
You won't lose your collateral, but I think you'll lose your position.
One of the things that we're missing
So
here
it's
is
not, 6 to 1.
That's a good point. I mean, we keep talking about tri-party as though it's a silver bullet. I mean, all our derivatives counterparties we use tri-party arrangements with. There's still the risk that the position that you have with that dealer moves in your favor while you're trying to replace it, and that you incur costs that way. So this idea that somehow having a tri-party arrangement with one counterparty so totally eliminates your counterparty risk, I think is a little bit disingenuous. It really doesn't. The other thing I'd say is I don't think anyone's suggesting a model for clear derivatives where we do bear fellow customer risk. I thought that was sort of off the table. So we seem to be spending a lot of time talking about fellow customer risk. I thought what was being proposed here was this LSOC model where that's been eliminated as long as you think it works.
I think no matter where we end up in terms of segregation, I think as an FCM, as Bob suggested, Barclays does agree and would be willing to show our risk management procedures and policies, and we do talk to our buy-side clients about that. One thing we are extremely cautious and will continue to be is the client confidentiality and the NDAs. So this is a big concept that when when buy-side firms are looking at FCMs to provide clearing services, we are often, I'm sure my colleagues from the FCMs are asked, who also do you clear for? We have not said any time a specific client that we are providing clearing services for. So if Barclays is providing clearing services for any of the individual firms on the other side of the table, we do not say that, nor would we ever give out any position level information. It is very important to us that in whatever paradigm is set up and how you evaluate from a risk management, buy side and their trades that they've put on that we are servicing remains confidential and does not leak to the market in any side.
And just to be clear, if on the other hand somebody from the clearinghouse came and said, you're our member, we're auditing you, we're reviewing your work, we need to know this kind of information, is that information that they would be able to get?
To be honest, I would have to go to my compliance team and legal team. Just someone showing up and saying, I'm from the CME, I'm from ICE, that would not be enough. Once it was cleared from compliance and we are going to take so much caution on that, I can't tell you. So yes, from a regulatory standpoint, whatever is acceptable to the community is fine, but we will guard our clients' positions with tremendous emphasis.
And we don't tell either. So when we know where people clear, that's very confidential information. And I'm very sympathetic to the fear about the fellow customer risk. But I'm also very sympathetic to the fact that none of you would want your information disclosed. And so there's a balance on the other side. And I think there are probably ways to get some disclosure that would be anonymous and reflective of risk profile without being reflective of exact client mix. But again, I heard both of you loud and clear.
We're not a proponent of that. We're a proponent of
rather have
the proposed rule.
You'd rather
we don't have to worry about that.
Optional physical segregation.
And just to be clear, Kim, my question is not whether I know you folks don't disclose things, but when either Dale Michaels' people or Ann Bagan's people go in, they do get access to information that cannot, for confidentiality reasons, go to fellow customers. Is that?
Yes.
Just an important distinction to make as well. We do keep talking about the bilateral arrangements, and I think it's been raised, but just to make sure everyone's very clear, you have protection of the collateral you hold there for the P&L on your positions, maybe for your independent amount as well. But then, if that broker goes into default, you have replacement cost. That's the difference here that we're talking about with clearing. You do not have to replace your position, and that could have, we've just talked about it, 600 trillion. Long-dated, illiquid markets, highly volatile. You do not have to go in the market and replace your risk. That's the insurance you're buying here, rather than anything else.
Let me ask a question about the bilateral arrangements. Jim, you mentioned the tri-party agreement. I think, Richie, you mentioned that as well. So essentially, if you have a deal, a trade with a dealer, and the dealer asks you for collateral, if I understand you correctly, you put up the collateral, but it goes to a third party who holds it. So the question I have is, legally, how does that party hold it? Does that third party hold it in trust for your counterparty, number one? Number two, if there's a default, or if your counterparty goes bankrupt, you mentioned that in layman you got your money back. How secure is that? In other words, is that purely a contractual right, which a court cannot touch, or is it so secure that in the event of an insolvency, you're very comfortable that the money will come back to you?
So the way the account is set up is when we have collateral to post, the custodian, which is a third party unaffiliated with either one of us, will open up an account in the name of the GM pension plan for the benefit of the dealer. Okay? The collateral that's posted is ours and remains in our title. I mean, we're the legal owners. They're a beneficial owner to the extent we default. But if we don't default, it's still ours. Similarly, if the dealer has to post collateral, the custodian will open up an account that says, X dealer for the benefit of the GM pension plan. In an insolvency of either one of us, which for pension plans is not something that can happen, in the insolvency of the dealer, what happens is that we then have the ability to close out our trades, and under the agreement, subject to bankruptcy law, we're able to pull back that collateral in payment of the amounts owed. And so, yeah, we are very confident that that works, and it has been tested, and not just in the Lehman situation, but for other counterparties that have defaulted over the years.
So, and just to add to that, these are control accounts under the UCC. So there's a perfected security interest in the assets held in the account.
By you?
By the secured party.
The secured party. So the secured party has a security interest.
Perfected security interest. They would deliver a notice of exclusive control to the custodian if the pledgor experienced a default and they closed out the ISDA, and the securities intermediary would transfer the collateral to the secured party. Likewise, the industry is working through documentation so that the pledgor is also protected in the event the secured party suffers a default, so that the pledgor can get the collateral back by sending instructions to the securities intermediary. So it is it's within the regime of the Uniform Commercial Code, well established to create the perfected security interest for.
The reason I ask you these questions is what you're trying to do, and let's be frank, you're trying to replicate what you have in the bilateral world in the cleared world. Right? That's what you're trying to do. And what I want to know from the FCMs and the DCOs is, can that be done? One. Number two, if it can be done, how much does it cost? And number three, how long does it take? Because the one thing that's...
Can I add a four?
Yeah.
Is that equally effective to protecting your ability to access that money in the event of a default? For instance, one question in my mind as I'm thinking about this is, there are security interests. So as I understand it, your counterparty has a security interest in the amount you've posted with the third party. My question is that a margin payment within the meaning of the financial contract provisions of the bankruptcy code, such that essentially they don't need to do anything to enforce that security interest? They can just grab it in the event of your bankruptcy. Essentially, do they have the money, or do they have to go and get the money? And that then the question goes to you folks. Are you happy with money that is not in your possession, but rather is held at a third party in which you have a security interest?
Can we just be clear that we're talking about initial margin and not variation?
Right. And the one more point I wanted to add is, in the bilateral world, there's just one party asking for collateral. It's your counterparty. In the cleared world, it's both ways. But let's say you're being asked for collateral. In the cleared world, there's two parties, and they're not related to each other. In other words, there's the firm that's asking you for collateral to protect itself, and then there's the DCO that's asking the firm for collateral. So how does that change the whole dynamic? That's what I'd like to understand.
And Ananda, I think, to answer some of these questions, I doubt that right now, the way these things are structured, they would fall under the Commodity Exchange Act as margin payments, because they're bilateral transactions. But I would assume that the documents could be written in such a way that there was an acknowledgement in the document that the payment was margin under the Commodity Exchange Act, and if there was a default, it could be seized as such. So I think you could get around the legal distinctions about it. From a clearinghouse point of view, there are definitely two ways to structure it, and I don't want to get in front of what the dealers might prefer. There's the way to structure it where the dealer has the account for the most part, and then it only becomes the clearing's lien when it is passed through, because they might have more collateral. You might need two accounts. There's definitely a way that you could make it work. I think that from a clearinghouse point of view, I feel like it gives the customers better protection by far than the LSOC model, because it is absolutely clear at the time, and it is clear to the clearinghouse whether or not that customer defaulted, and you don't have to unscramble eggs. So from that point of view, I think it gives the customers who are using it much better protection. I think it costs more, and so I would hesitate to have us set up an environment where every customer had to bear the cost of that if they did not feel it was worth the trade-off, and where the dealers would have to bear the cost of that for every single customer that they had instead of customers of whatever the appropriate scale would be, and same thing for the clearinghouses.
Just to make a point, I think the collateral what we're talking about would be DCO eligible collateral, which is a restricted set of collateral. If you have in mind a whole range of collateral that you now pose to dealers, it's not that.
So, Kim, point of clarity, if I may, you're saying it's superior to LSOC and it is legally segregated. How does it then fit in the waterfall? I mean, how does the current FCM model treat that subject to the waterfall?
Well, right now it's not allowed under the waterfall, right? So in a world where there was physical legal segregation, the way I would see it is if the customers who had the physical legal segregation would operate as, think of them as pools of their own, right? And they would make settlement on an individualized basis, so it would be clear whether or not they defaulted. And if the customers who didn't choose that option, if one of those customers defaulted, that would be a pool, and it would be managed as such, and the customers over here in the separate pools would be free to port without having to wait to find out if there was more money coming or figure out which one of them actually was the one that drove the default. If you have enough money in your account to be meeting your obligations, you didn't default to the clearinghouse, you can pick up and move somewhere else, and believe me, we would be helping you to do that if you needed help. Because it's in everyone's best interest that as many customers as possible are able to not have their trading disrupted, not lose their hedge, and not lose their collateral. So we're all very aligned in that regard. It's the uncertainty becomes, the uncertainty of the LSOC model is where it becomes harder for me to be comfortable that you would get what you want.
And the bankruptcy, you all had a bankruptcy debate prior. Are you confident? First of all, this doesn't exist today, so it's not an option.
Our attorneys feel like it is. I don't think that they've been able to convince the CFTC, but I think there's definitely room for discussion. There's definitely viable interpretation that says that it's okay.
We just think to be clear, you mentioned your attorneys think that it is, and of course we got something from Mr. Salzman, who said he was speaking on his own behalf, not on yours. But in any event, beyond that, which is on our website, is there any other analysis that you're aware of that explains why this would work?
I don't know that we have shared anything else with you, but we certainly would be happy to. And I mean, one of the other distinctions, and I'm not a lawyer, so I'm at a disadvantage in having this conversation with you, right? But one of the other distinctions is that the ratable distribution only applies to things that are defined as customer property, and I don't think that collateral like this in these third-party accounts held at a clearinghouse would necessarily be customer property. Therefore, it's not part of the ratable. It's not subject to the ratable distribution.
Okay, so just to make that clear, so what you're saying is customers would be posting this collateral, but it would not be eligible for treatment as customer property under the bankruptcy code? I mean, in other words, there's a bit of a bitter with the sweet issue. That is to say, the bitter is that the ratable distribution, there are some sweet things about being treated as customer property and protected as customer property under the bankruptcy code. And so I guess the question is...
In this circumstance, what would those be?
Essentially that you are treated, for instance, what we saw in Lehman, that instant transfer where essentially there was this separate estate that got to be transferred out without waiting for essentially the bankruptcy process to work its way through and people eventually collecting. Customer property essentially can be moved. For instance, 764B, we get to approve, and we have by rule and could by order approve transfers, which are then not subject to clawback, things like that. Those are good things that customer property benefits from.
And these are things that I presume that you...
Yeah, I think you've hit the nail on the head, that you by regulation. And so, in terms of the analysis, we did have a law firm look at this, and the viewpoint was, is that the bankruptcy code requires that the distribution of customer property be done ratably. Ratably is focused by Part 190, which provides that ratable distribution is done by customer class, and then the customer class is actually done by you. And in your adopting release that created the concept of customer class, the reason for, and I'm quoting, the reason for identifying classes of customer accounts is to permit the implementation of the principle of pro rata distribution so that the differing segregation requirements with respect to different classes of accounts benefit customer claimants based on the class of account for which they were imposed. The customer account categories are such that there's broad flexibility. For example, you've got an account for a leverage account. It's not based on who the customer is. It's based on the type of account strategy that's being employed. We think you have the regulatory authority to make a customer account for those who pick full segregation. We also believe you have the regulatory authority to deal with the customer property issue that you were just talking about. And so we do think that there is flexibility to take this tri-party, and we talk about costs. Let me just take a second on that. There exist today these custodian accounts. It's a contract. We all, under the CFTC regulations, are going to have to revise all our derivative contracts. So we're already there. No more additional cost. One additional thing that we could do here in our contracts is to revise it to give the DCO direct access to that collateral. We could provide it in a way that accomplishes the concerns from a systemic risk, not adding any more accounts because there already exist. And we would give the FCM the rights that it needs and would give us the third-party record-keeping, reporting, et cetera. One of the great things about internal controls says separation of duties. One of the bad things about the FCM model is the futures model is there's no separation of duties. The DCO relies on the FCM in many of the clearinghouses to tell them what their customers' exposures or collateral is. The FCM tells us what our reports are. The great thing about this model is it permits everybody, the DCO, the FCM, and the customer, to get transparent reporting and still keep costs down because those accounts exist, and all we have to do is change the contract, which we already have.
And so, speaking to the bankruptcy point, and this, of course, came up earlier this morning in terms of whether the account classes work, and folks expressed a great deal of confidence in our ability to pass regulations that would make that work. So back 14 years ago, Griffin Trading went bankrupt, and there was a challenge, basically, to our rules under Part 190, which said that basically we got to count everything as customer property. And Judge Katz in the bankruptcy court in the Northern District of Illinois basically said, sorry, CFTC, that rule was beyond your powers. And so having been through that and been part of that, you can understand why I've got a little bit of a concern to make sure that we don't go beyond our powers and start putting things in the regulations that are beyond our powers, and then people rely on them, and the industry builds up a structure around that, and then a bankruptcy judge chops it down, and then all of a sudden all the things that folks are counting on aren't reliable.
But the Griffin example, wasn't that the case where we were trying to have the customer as a class be a preferential creditor to everybody else for everything else the firm had? It was not a question of there being a question about the things that were actually customer property.
And that was the facts of that case. But the point I'm making is that if we go beyond, again, the bankruptcy code has a structure, and part of that is 766H and the rateable distribution. And so the challenge then won't be from other creditors against the customer creditors, but it'll be between customers. And we're subject to the same thing where you have somebody who's not getting what he thinks he should, and he thinks the law entitles him to, going and challenging our regs, and bankruptcy judges who, in my experience, are not always entirely enamored of our regs, looking at them and basically being able to say, maybe they'll say, yes, actually, you got it just right, but on the other hand, it's also possible they say, sorry, you've gone beyond your powers, And if that were to happen, then in the middle of a bankruptcy, we have essentially a change. And again, the industry, one of the things I've learned in terms of the implementation issues is the industry needs to build structures around our rules, and you need to implement them, and it's going to cost people a lot of money and time. And if we put out a rule and it gets undercut, first of all, it would be undercut at the worst possible time, and secondly, it would undercut what might be some very expensively built structures. And so that's the reason for caution.
Bob, having heard that there are different legal interpretations from different lawyers that are advising the firms around this table, that's a risk that we all take, just like market risk. Again, wouldn't it be better to give the market participants a choice and let them decide which risk they'd rather take? Would they rather take this legal bankruptcy risk, or would they rather take the omnibus risk? And then let the market decide where it wants to allocate its resources.
So your point is,
I'm sorry, and then disclose that this risk exists, but not warrant it.
the concern for us is if we take the legal risk, and if you have a catastrophic insolvency, then it would have an untoward an outcome on market operations that nobody wants. And I'd like to know what the DCOs think about this, because as Kim pointed out, that in most of the issues that we've dealt with in the past 10 years, we've been lucky in that there's not been any instance where there was difficulty in moving positions. For example, in Lehman, we went to court and the judge agreed with us and everything went fairly smoothly. But what I think I'm concerned about is, let's say we say, you know what, fine, you take the risk, you have customer choice, and let's take the risk that the judge will agree with what we think. What happens if the judge does not? What happens if you've got a fairly significant firm which goes under, and there is a great deal of uncertainty, positions can be transferred, or even worse, where the judge says no, liquidate all positions. So that's the concern, I think.
And that is a real issue that everybody would need to think through. And maybe it's a good point that everybody should have the ability to think that through themselves and make their decision. I gotta believe that the contracts that are around these third-party custody accounts have the ability to stand up to bankruptcy issues anyway, or they wouldn't have worked in the Lehman situation. So I'm not sure. I almost feel like we're going to have belt and suspenders in terms of the protection, because there's the contractual provisions that stood up in a non-CFTC regulated bankruptcy, and then there's the CFTC regs layering on top of it. I got to believe it makes it better, not worse.
The question is whether they work together. And I guess one point I would make to try and get towards tying this up together, which is, look, there are a number of views that have been expressed, some secondhand in terms of lawyers. We're eventually going to have a comment period once the Federal Register gets around to publishing. One of the things we would very much appreciate, if people have divergent views in terms of the legal issues here, is, certainly if any one law firm were to file essentially a comment in the nature of an analytical memo that would help explain why there might be a divergent view, that would be very helpful. In other words, we can, as a practical matter, sitting around here, we can't go too deeply into a complete legal analysis. On the other hand, a comment which basically says, well, I think X, is nowhere near as helpful as an analytical comment. I think X, and here in detail is Y, is the reasons why.
But Bob, do you have the same issue with LSOC as it's being proposed? Are you just dead certain, and it's legally tied up, that LSOC absolutely under no conditions could be misinterpreted or turned over in a bankruptcy proceeding?
And here's why. Because under LSOC, at the end of it, if you liquidate, what you would be giving back The idea is you would have to give back to the trustee whatever's left of the collateral that is attributed to each of the customers. Thus, the fellow customer risk would not be realized. Liquidation issues, separate story, I realize that. But the fellow customer risk would not be realized because essentially you would be looking at those positions customer by customer by customer. That money would then go back to the trustee, and the trustee would be distributing that ratably. And there wouldn't be the fellow customer losses because that would be a ratable distribution. In other words, the intention, the design, and again, are you asking, am I quite confident? Yes. Is there basis for others to question it? Of course. But what I'm saying is that the intention was to design something that would work with the grain of the bankruptcy code, with the concept of ratable distribution, rather than trying to get out of the bankruptcy code and saying, okay, we're going to have something that, well, we'll distribute it individually rather than ratably, but to keep the ratable to protecting all of the customer collateral.
Bob, one of the things that you talked about is the ratable distribution, and as we noted before, that's by customer class. Yes. And those classes are already done. You've already established customer classes, and so if there's a risk that a customer class, that whole concept of a customer class won't be honored in a bankruptcy, it's not a new risk. It's a risk that exists today for every customer class that's out there. And so if a bankruptcy court were to say that the CFTC does not have the authority to set customer classes, they could do that today. So we're not creating a new risk. It's a risk that already exists. And in addition, those customer classes, you have the flexibility to provide, as is the release said, for the concept of customer class, to accommodate different segregation requirements. And we really do think that the law is pretty clear, not unclear, that you have that authority. And if there is a risk associated from different interpretations, it's a risk that we're living with today.
I think I'd have to challenge that. I'm sorry. I think all of this may have a certain amount of legal uncertainty to that, but the Commodity Exchange Act requires segregation of customers, depending on, are you trading futures? Now, are you trading swaps? There is nothing in the Commodity Exchange Act that says you can establish separate segregation requirements for customers trading the same product. The bankruptcy code, I think it may be accurate to say that does not mention account classes, but it does define a claimant's right based upon whether or not it is a customer, and it is a customer with respect to certain products. It is a customer with respect, it has a claim against an FCM for if it's trading futures on a U.S. futures market. It has a claim against a U.S. FCM if it's trading foreign futures. It has a claim against an FCM now if it is trading cleared swaps. Those are the account classes that I think the bankruptcy code contemplates. All of this requires a lot more thought and a lot more detail, and I think Bob's point about legal briefs or memos makes a great deal of sense, and I think it would be helpful, quite frankly, if all of us had access to everybody's legal memos so we could sit around and really kind of hash these issues out. These are not simple issues, and there are no simple answers to them. And I just think, it is troubling. I mean, what I'm hearing over here, quite frankly, is you don't like the Dodd-Frank Act requirements, and that's fine. I'm pleased to know. I'm not pleased to know. It's if that's what you don't like, that's fine that you don't like them. I think Bob and we are trying to deal with what
Yeah, I don't think that's the case.
And just to follow up on that, just to follow up on that, I mean, essentially, and Kevin, you're quite right. I would note we did in the release, footnote 91. I'm not sure where it's going to be in the Federal Register ultimately. Discuss, going back to the 78 Bankruptcy Act House report, how they were looking at different types of customers, separate estates for leverage transaction merchants versus for options customers. And again, I think the point is, Yeah, and we will, we put, of course, Mr. Salzman's comment on the website very quickly, and, as we get these things in, we would be delighted to have them, to read them, and to put them very quickly up on the website so that to the extent there are differing views on this point, they can be informed by the legal reasoning, and basically folks can, we can do this on an analytical basis. Because, of course, there's a limit to how much we can do this.
Absolutely.
Yeah,
One last point here. The footnote 91 that you referred to refers that the CFTC thought there was a problem with separating classes other than by kind of customer in each customer class. And the reality is that's already been done. For example, the CFTC created the deliverable account, which is based on the method of settlement and not rather the kind of customer. There's also, Mr. Foley, across accounts, one of the customer classes is leveraged accounts, which is really, to my knowledge, not product specific.
No, that is product specific, and it's just a product that's not being offered. But at the time,
then I
it was
stand
product
corrected.
specific.
But the point is that we believe that there is a basis to do it on, for example, deliverable accounts, on other than just the kind of customer.
Bob, we started off on this path with what's the impact of this model versus LSOC for the DCOs and FCMs. So may I bring us back to that?
Yes.
Looking at it very simply with a risk cap rather than a lot of the legalese around this. Under LSOC, the DCO has the money from the FCM, from the client in its account. Under this model, it doesn't. So I know which one feels more certain in the first instance. Then let's talk about what are the impacts in terms of implementation and the impacts on the DCOs. And I'm not saying we can't get comfortable with that, but in that construct, it's not in our powers to hold that collateral. So in our account is better than not in our account, just being very simple about it. But then you've got some operational complexity. If you've got 1,000 clients, they're likely to have more than one FCM. There's going to be, therefore, say, 3 FCMs. Therefore, that's about 3,000 collateral accounts. And you're going to have more than 1,000 clients, one would expect. And each DCO would have to sort of have similar in each of the custodians. And then you're going to have to talk about, is it one custodian or more custodians? All of these things are achievable, but there's layers of complexity and reconciliation and pipework that need to be built to be able to do this. So there's those angles. Then we also have to look, when you put your collateral into a custodian, you're transferring the credit risk from either the FCM or the DCO into the custodian as well. Custodians may go pop as well. So there's assessments that would have to be considered around custodians as well. And on top of that, my concern with going down this route, in the first instance, I think LSOC is one step towards it, but in the first instance of moving down this route, is it will, some of the people on the other side of the table, I'm sure, have very high-grade quality collateral that we would accept as DCOs. I would wager that not everybody on the buy side does. So it could become a two-tier structure where those with collateral that is acceptable to the clearinghouse, because you have to have acceptable to post it to the clearinghouse direct, they could use this kind of model, whereas those clients that didn't necessarily, they wouldn't be able to use this model unless we as DCOs went down the collateral curve, the credit curve, and took less liquid, credit-worthy collateral. So that by moving down this route, it puts further pressure on the DCO to take a broader range of collateral in 1.25. So just need to be cognizant of where this would lead, and also disparate between some clients that have good collateral and some that don't.
Yeah, I mean, I think, Dan, some of the last point of it is, the type of collateral under 125 is already a limited universe, right? And not everyone represented from the buy side holds all of that type of collateral all the time when they need it. And there's going to be an unintended cost for that acquisition of that collateral if we're going to post direct through that and not use the intermediation factor through the FCM to get through there. It's problematic. But one question I wanted to ask, we talked about the LSOC model, and you went through why you think it's better than the other alternatives from a legal structure perspective. Isn't it also theoretically possible that if we go through the liquidation, we do all the things that we have available to us in the toolbox in the time of stress, the loss for the buy side is going to be greater than what their fellow customer loss could be in that scenario by the time they go replace the positions, the P&L, the move, and all that in order to get back to a net position that they were in before?
And
Was there any thought around that during the development?
let me answer that question. Then what I'm going to want to do is have us move on a bit, and then we might come back to this because later on in the agenda we're going to talk about specifically operational costs and risk costs, and then I will want to try, maybe after we talk about those, sort of turn those back and talk about optional models in those terms. But in answering your question, Chris, as I see it, if you're doing things on an omnibus basis, then essentially there's either enough money in the account or there isn't. If there's enough money in the account, then under any model, I mean, this is REFCO, this is Lehman, under any of those models, it's just a matter of finding someone who can handle the book and transferring it to them. But that's if there is enough money. In other words, if the loss wasn't from a fellow customer. But if there was a fellow customer, then I'm trying to see how there would be a greater loss to the customers if their money is at risk, how there could be a greater loss if their money isn't at risk than if you're entitled to look to their money, their collateral, their value to make up the loss of the fellow customer.
Could completely be wrong about this, but if the fellow customer loss is $1, okay, on a pro rata share, and we have to liquidate because that dollar's not there, so we, the DCOs, come in and we liquidate those positions, close them out, hand the collateral back. It's all there. Everybody's happy with the collateral. But because we liquidated those positions, they need to reestablish those positions for what it means to their book over time, and it takes a few days to do that. And when they reestablish those positions, they're in a worse off place than they were for their overall book for the buy side. Did it cost them, does it theoretically exist? Did it cost them more money than that?
But I guess what I'm saying is that's an apples and oranges to my mind, and here's why. Essentially, there's two separate questions. One is, based on the circumstances, are you going to liquidate? And so if the loss was $1, I'm going to think under any of these models, unless the market was really, really bad, you wouldn't liquidate. I guess what I'm saying is, if you're comparing, well, if we go under LSOC and we do liquidate versus if we go under the futures model and we don't liquidate, well, yes, of course, it's going to be more expensive on the first than the second, except I don't see how you get there because how is it?
You and Kim had the conversation this morning about are the customers in default or they're not in default. And as a clearinghouse, we have to make a decision with a finite period of time. And I'm just proposing that there could be, and I freely admit that could be wrong here, but the time value that is there, at that moment in time that the clearinghouse makes that decision. You and I have had a conversation about duty of care from clearinghouses to members and to their customers over time. We make the decision to liquidate because we had no visibility to that other side. The net result is there is, from a collateral perspective, we're in a whole position, but from a market perspective, the buy side ended up worse than the other.
But what is the circumstance where you would do that under the LSAC model and you wouldn't have done it under the futures model?
I don't know that there's a circumstance where we would do it under the LSAC model where we wouldn't have done it under the futures model, under the pooled model, because basically the event is the same. The triggering event is that the FCM did not pay, and so the way I have thought through the unintended consequences of how LSAC works, I think we're going to end up in a place where we're going to collect from the FCM all the sum total of all the monies that are due and owing from all the customers who owe first, and then we'll pay them the monies that are due and owing to the customers who made money. So it exaggerates the settlements, and we can manage around that by letting the banks at least know the other side's coming, so that they can net it off on a credit basis. But the FCM is either going to pay or they're not. And then there is a decision, and I actually think this is one of the decisions that would be also very challengeable by customers who don't think they were treated fairly. All the customers who owed us money, none of them paid. And so if we decide that we're going to let some of them take their money and their positions and go somewhere else, then I think we'll be in a position where we'll get challenged by other ones who would have thought they didn't get, maybe they couldn't port, maybe they didn't find an FCM quickly enough. I don't think it's foolproof.
No,
On that last point, I will note that we did, I think it was in 190.06, explicitly give you folks the power to do partial transfers. And we mentioned in the preamble that we reinforced the importance of your ability to do partial transfers.
Yeah, so my only point was I agree. I mean, you could, in an extreme case, you might expect every customer who's up on the day to be able to port to a new FCM very easily, and you just be left with the guys who are down on the day and wondering whether they're going to meet the margin calls. It's kind of extreme, but my only point was I don't see how this is any worse than the existing futures model. There is absolutely, you could have replacement cost for customers to replace positions, but I think you've got that in the existing futures model or the LSOC model. It's the same deal.
I'd agree with that, but just to a point.
Actually, I think it's the opposite, because in the existing futures model, you're absolutely going to get your positions. Your money might be a little bit behind, and it might be short, because it might be a pro rata distribution. But you're absolutely going to get your positions, because it is very clear that the positions can be transferred to another FCM at the current kind of mark-to-market value. You don't take your equity with you necessarily, but you definitely preserve your position much more certainly, I think, in the omnibus model.
Why so?
No, I don't see that.
Because in addition to the issue that, of course, you'd need to be able to remargin, because the transferee is not going to take those positions without the collateral, how is it, and happily we've moved down to the next point on the agenda, portability. How is it easier to port the positions under the futures model versus the LSOC for an individual customer?
For
group, take your pick.
If you know who defaulted, you absolutely can transfer the positions of the non-defaulting customers in the futures model. You can't necessarily send the money right away, but I don't think you're going to be able to send the money right away in the LSOC model either, because you need to liquidate it. The clearinghouse is allowed to liquidate the collateral, and if the collateral comes up short, everybody takes a short payment on the investment risk, basically. So I don't know that the collateral, it can move. It will be circumstantial. It's not a guarantee.
Right. No. I'm just saying, how is it that it would be? I can understand it. I could understand an argument that it would be the same. But my question is, I thought I heard you say it would be easier to move it under the futures model than under the LSOC, and that I do not understand.
The
positions.
The positions. I mean, it's absolutely clear to me that we would move the positions of the non-defaulting customers at current market prices without money if the clients wanted them. And so if the clients can find another home and can remargin their position, they can transfer it right away.
I think that's the key. They have to remargin, so they'd have double margin. That's the key point for a period of time, which is the same under both.
Why wouldn't you let them do that under the LSOC model?
You could. It's identical.
Kim?
Just
that's
to be
the
clear.
question. Why wouldn't you do that under the LSOC model? Put for the moment the margin aside.
I could do that in the LSOC model for the customers who made money the day of the default, but I can't do it for the customers who lost money the day of the default, because every one of those customers technically has defaulted, and until I find out if I can get more money from any of them, they have all not met their obligations to the clearinghouse. Therefore, I have an obligation to preserve the right to take the actions that protect the rest of the clearing members from exaggerated losses, from not taking advantage of the ability to liquidate the positions of all the defaulters.
But Kim, I don't get this. Why haven't they defaulted in the omnibus model? I mean, why is it different?
Same.
Seems to be a double standard. Futures model,
it's the same thing,
LSOC,
right?
whether you're a winner or a loser.
Either you know that these 4 people that paid the money, or you don't.
And to go one step further, I think all 3 of the FCMs, there's more than us, are shaking our heads. We can't, if we're a good standing FCM, we cannot take the positions without money coming with it, because we're going to end up with the positions that we are then going to own, and the margin may not travel with us.
No, clearly the client needs to remargin.
I think the key to all of this is that DCOs take good collateral, and then this whole thing disappears.
I think we're trying to understand better how one client's default gets attributed to multiple clients who have actually performed. And if there's some technical glitch in the drafting of the proposal, I think that we should, because I can't imagine that was ever the intention of the drafters, and it certainly wouldn't be our expectation in supporting LSOC, which we do. So I think we should try and identify what that glitch is, because I cannot imagine that any of us wants the default of one client to tar the rest of the client base that has performed.
No, and to be clear,
but
just for a second.
By definition, the way the thing reads right now, by definition, people have not performed if they haven't paid, right? So the clearing member either pays or doesn't pay on behalf of the losses that it suffers to the clearinghouse, which is likely to be the sum total of all the losses that its accumulation of customers suffered. So every customer who lost money the day that some customer's failure causes the FCM not to pay is by definition not in compliance with the requirements to have paid their P&L.
So
there will be a period of time where we try to get that money so that we can make sure that that customer is whole before we would be willing to transfer. I think it will be circumstantial, but I think you need to make sure whether or not you had a customer who was or was not a defaulter. It's harder to determine which customers were or were not defaulters than I think it is in the omnibus model.
So Kim, under the omnibus model, if I'm a customer, I've got certain positions. First off, you don't know me until I introduce in other words, after the default, you don't know me until I introduce myself. But those positions may have lost money on the day of the default. You haven't gotten money for them. So in fact, you don't, under the omnibus model, I'm not sure you know anything about me other than what I tell you, and indeed my positions may well have lost money, but I still want to transfer them because actually I had already paid the FCM, and I promise you that's the case, but you don't know that. So I'm not sure, under that case, I think if you're willing to transfer me, then you're willing to transfer me despite the fact that there was a default that touched my positions. Switching to the LSOC model, we did put in things there to make it clear that if I had, again, using my example from this morning, if I had $1,000 worth of collateral attributable to my positions and those positions lost 100, CFTC was not going to force you to give me back $1,000. You were perfectly free to apply that 100 against the $1,000. That doesn't mean there's any reason for you not to transfer those positions and $900 to another FCM. And I'm not sure why you would have any greater right or incentive to do that on the LSOC model than under the futures model.
I think it's because the way that I read it, we're making a decision that potentially makes the loss that is mutualized across all the other clearing members worse versus one that doesn't change the position of the loss that is applied for all the other clearing members. Remember, we're trying to balance the systemic risk containment of not bleeding losses over to parties who were not
right, but
the defaulter. And so in a case, in a pooled regime where I am entitled to use all of the collateral that I have, if I let positions go with no collateral because customers want to put their positions, I've gotten rid of exposure without collateral, I have not worsened the loss that's going to go across all of the other clearing members, and I have more flexibility to do that. I might not always be able to do that because it might be that all of the positions that want to move actually do worsen the ability to liquidate the portfolio, but I have better flexibility to do it because I'm not worsening the loss. Whereas if I let a customer go who actually didn't meet his obligations, and I would have had the right to liquidate his collateral and his positions in order to reduce the losses that the other clearing members would suffer, I might be making a decision that worsens the loss.
Again, we're not talking with recourse. So essentially, at least the way it was meant to be written, and if it was imperfect, mea culpa, but essentially, I've got a set of positions. Collateral of 1,000, I've got credit for that. There was a loss then of 100. And so what you have is, you can take that 100 out of the 1,000, And if you transfer the positions, then I'm not sure how any of your other members is made worse off by transferring the positions to another FCM. And again, you're taking that 100. That's what I owe you. You're taking it out of the 1,000, only transferring the 900. I'm not sure how you're making any other member worse off.
Bob, can I give you an example? We have this model live in Europe, and we test this, and I can tell you how it works. I'm going to pick on the three gentlemen there, Richie, John, and Rupert. I'm going to pick on Richie and say he's the defaulting client because I know that I'll wind him up. In that instance, we have a client that's taken down a clearing member. Each of these individuals had a risk of 100, and it's collateralized of 100. I don't care whether it was T-bills, corporates, whatever. I've got collateral value. We're talking ELSOL now. You're giving me 100 each. And each you have a mark-to-market on your portfolio of 50. So at the point of default, John says he wants to go to another clearing member because he's legally segregated, operationally commingled. I say to John, okay, John, you've got 100, and your mark-to-market was 50, but by the time you port to your new FCM, the market has moved to 55, so you've got to make good on that 5. I say, let's go the other way around. 45, you've lost 5. So I migrate you across. I say, you go to another clearing member, Ray, maybe, as he said, I'm only going to take you if you give me the 100. But also we insist you must make good on that other 5 lost. That's accrued in the period of time from the default until such point you've paid the VM. I'm going to do the same with Rupert. Rupert wants to go to a different clearing member. He's lost 7, so he's now down to 43. We go, okay, you're going to go to one of the other FCMs. We take you with 100, collateral value of 100, not the same piece of paper you gave, I'm afraid, but over you go. And then Richie, we're going to close his portfolio out. Now, if the situation arose whereby when we liquidated that collateral, we didn't get a value of 100 for John and a value of 100 for Rupert because we'd haircut incorrectly, under the European model, we incur that's actually a loss borne by the clearinghouse and the defaulter's estate. So we say, we're confident in our risk management. We will take haircuts. We'll price the collateral on a daily basis, and we expect to be able to close the collateral out within the assumptions we've got in our risk. And if we don't, that comes out of the waterfall. We don't actually redistribute that across the client, so there's no investment risk there as such, I think as we call it. So that's pretty much how it works in Europe and how we test it. So in the US model that's been proposed here, if we did have a reduction in the value of the collateral and there was a loss, we'd expect those guys to still port. We'd take the positions, but let's say rather than having 100, it was 98 because we miscalculated the haircut. We'd ask John and Rupert to pay an additional 2 to Ray and the other FCM to make good on that. We're not going to not send them because they've only got 98, not 100. We'd send them across. They'd have to make good to make that successful as a transfer. And if they didn't, we say, sorry, you can't go, and then it's either pay or we'll liquidate. So that's how it would work in either US or European. One way to take this issue off the table is follow that similar model whereby it's the clearinghouse that bears the risk and has to have confidence in its haircut, collateral, etc.
And Dan, what you were saying seemed to be that Richie had defaulted. There was a market loss on the other 2 positions. Kim was saying she wouldn't port any of them because of the combination of the default and the market loss, and you couldn't therefore determine at that time who had defaulted.
The problem is that they would be defaulting clients where you would be entitled to the liquidation of their collateral in positions if you needed it, and you wouldn't know yet what you were going to realize on the sale of the collateral. You don't know what the loss is going to be.
But it's sort of odd because they wouldn't really have to pay their part of the margin until later in the afternoon, and you would consider them in default in the morning because the clearing member was in default in the morning. That seems a little odd. Well, certainly you would like some assurance that they would be paid.
The clearinghouse has to make a decision, as Chris was saying, at a very specific point in time. That's why the mechanism works, is because it's very clear when there is or is not a default.
I still don't understand how it is. So again, you've got 1,000 of collateral attributable to me. There was 100 loss on that, and there's the position remaining. Now, I can perfectly understand you're saying, Bob, there's no clearing member, there's less than 1,000. We're going to liquidate you because, we don't want to risk further losses. Got that so far. On the other hand, if I say, wait, Kim, Laura over here, she's a member in good standing. She'll take that position. She'll take it with the 900. I've made arrangements with her to get the 100. The clearinghouse, I don't see where the clearinghouse is at risk. You've got your 100 because you're taking it out of my 1,000. So I'm still not understanding why it is you're not willing to let me transfer over to her those positions and, either with or without the 900. But why aren't you willing to let her take the positions? She's a member in good standing.
I think the industry, from this conversation, it's important to come up with the most simple and easy to transact portability process. I mean, we have an extremely savvy, sophisticated group of people at this table, and now we're trying to explain exactly how it happens. So to Dan's example, if one guy went under and the other guys had 100, but their mark-to-markets were 5 million or 2 million, and we're obviously in a market that's really not tremendously stressed. The fact is, under the example, if that was to happen, you're probably potentially going to have positions that are moving 60 points. And so if you move a position at $100 million of IM and it moves 2, then the other FCM is probably likely to take it because they're going to be able to look at it and feel okay. The fact is, if you have 100 million and it potentially moves 60, or you're really not sure where it is, then you run the risk of having a portability situation that could be extremely chaotic. And it does concern people at Barclays. So I think no matter how we figure out how to do this, it's important that the market understands it and all the market participants understand it. Because when a port situation comes up again, hopefully it never does again in a basis, it's going to be in a chaotic market. And if we are having this conversation, think about the people that have not spent the time and the focus to understand this.
And I think that is absolutely why the DCOs have to be able to calculate risk, P&L, initial margin at the lowest level on a client ID level, because the FCM is gone. You cannot rely on them at this point. I need to know what every single client has got, what the P&L is, so I can see, in Ray's example, they're losing 60 of the 100. This is a big risk. I'm going to close that out unless they pay me that 60 now. That is absolutely fundamentally why the DCO has to be able to do this at the lowest granular level.
Which is an excellent
And it's going to be
segue
hard
onto our next.
and it will be hard for you to give the customer the opportunity to make the choice to give you the 60.
Okay, which let me
because
segue.
you don't have an arrangement in place with the customers the way you do in a physically segregated.
Okay, I got to keep the discussion moving. I apologize, but really I want to move. The next point on the agenda is operational costs, and I'm going to take Dan's comments as an opportunity to segue there, because one thing that is very clear to me is that the clearinghouses under the LSOC model are going to have responsibilities for looking at at a client level. Maybe not every client, maybe just those clients who are actually going to threaten the FCM, but that does raise at least some cost issues. And what I understand you to be saying, Dan, is that you already look at the client level because you believe that's necessary even today, even under an omnibus model. Kim, I understand you to have said earlier that under an omnibus model, but for swaps, because of your concerns about the products, you are also looking at an individual customer level. And so my question is going to be first, Chris, I just going to turn it over to you for a second, and then ask, from a clearing perspective, are there material operational costs in going to, let's start first with the LSOC model?
So in our current model on the customer business that's been cleared, we said we collect gross already. We may not know the exact identity of who that is, but we know it's a client customer, and we know it's a unique client ID at the clearing member that we have, and we know we're holding that collateral and potentially excess collateral being collected by the clearing member for their reasons, their defined reasons, separately, and it's there, and we close it out. So I don't know that there are material changes in that, although I would say it would seem to me, based on the earlier comments made by some of the members from the buy side, that reconciliation process is different than what they're accustomed to. So I think there will be operational requirements both from the DCO to the FCM to the end user, the buy side here, where there will be changes in process today that there will be some associated investment in. Okay, I can't tell you exactly to the penny what those would be. But that information, we don't route all that information back. We kind of take that information in, and as positions close out, the money flows accordingly. Whether it be excess margin coming back, that the clearing member does something based on the contractual relationship between their customer and themselves on that.
Let me turn to the firms for a moment. And in terms of, again, under one of the proposed rules, I think this is 12, you would be required every day to be passing information on individual customer exposures to the clearinghouse. My understanding is you already know that, but there would be a new thing in that you'd have to pass it upstream. Are the material operational costs from that, material operational costs from other things that I haven't mentioned?
From the swaps clearing, I think passing client ID and the client identity, and if there's a multiplier or some other multiplier that explains how much excess there is in the seg account for the client, I think that's a small build. I'm concerned, though, if we're looking at cross-margining, putting futures into the cleared swap account class. I'm not sure how that, since we don't today put a client ID on futures, how that infrastructure would work. So I think it's a cross-margining issue, but for cleared swaps itself, I think the build is fairly minimal.
If you were cross-margining today, wouldn't you, and you were cross-margining between, say, futures and swaps, wouldn't you need to have that at that individual client level to do the calculation for the client's required margin?
Yeah, I think we can. It's just the infrastructure is not there because the cross-margining is not really done in that fashion. But if we're reporting it up, we'd have to set up the infrastructure to do that.
Because you don't currently do that at a client level?
We don't do it in that same fashion. We keep the records separately, so we'd have to in a different system. So we'd have to submerge system, but it's not that hard.
Sorry, can I ask a question? It's a little bit off topic, but I think that the operational aspects of once a client went into the OTC pool to get cross-margining, I think we had foreseen treating them just like other people in the pool or other positions in the pool. So I think that we would be expecting that the client ID would be reported. But the real thing that Oliver triggered when he said that is for the cross-margining, if certain customers are opting to go out of the pooled segregation for futures and still trading the same products, but going into the different account class, that's a parallel. I think it's a direct parallel to having people opt to go out of the OTC account class pooled into a different account class that we were talking about with the physical segregation. Just a thought I wanted to
plan. I
plan.
don't think so because I guess, and harking back to the 2008 interp that we did, I guess for two reasons. First, all of the collateral then is margining, in this case, so let's say you put futures into the swaps account class. We're treating those, and indeed I think this is sort of alluded to in 22.1, we're treating the futures positions and collateral as swaps positions and collateral, and that's the nature of the 4D. Just as when we would do a 4D order today, and we're taking foreign futures and putting it in the futures account class, or cleared swaps and putting in the futures account class, we're treating those positions as positions of the new host. Second, all of the collateral margins the positions in the host class. So if you're cross-collateralizing between swaps and futures in the futures account class, all of your collateral is margining futures and therefore could be treated as that. So that's a different thing than saying, okay, we're going to be treating swaps, one group of swaps customers different than another groups of swaps customers based on the choices they've made for protection.
But they just chose to get their positions and collateral treated as subject to this other different new account class as opposed to...
No, actually what has happened is we have by order permitted these particular transactions to come into that account class. And again, the collateral regardless of whether it's margining futures. There's futures in that pool, but there's swaps, otherwise there wouldn't be cross-collateralization, and therefore all of the collateral is margining swaps, which is the nature of the account class that they're in.
I think there's many points about cross-margin. If you start putting swaps in a futures account, you're going to have impact on the futures default fund and all that. So, I mean, the cross-margining thing is important, but it's not really what LSOC's about. I don't think it's...
It would also affect the default management of the futures class, which would have to go from a 1 day to a much larger time span and so on. It would be problematic.
Let me ask if any of the other firm folks have anything to say with regards to operational costs, and then hopefully we can wrap this up in a few minutes so that I can permit folks to take a bit of a break.
Yeah, very quickly. I mean, Barclays is building what we hope to be a very flexible and dynamic system. On the base of LSOX, we have been fully servicing and clearing a client out of LCH since last year. Okay, so we're set up to do that, and from not only whatever regulatory standpoint we end up, whether it be in the U.S., in the EU, wherever across the country, our tools are extremely flexible, and we will continue to build more flexibility. In terms of the cost, the fact is an OTC is a little different than futures because there's a tremendous build that everyone's doing in the case of OTC. So if we need to build to LSOX, which in essence we've done it in the LCH European model, there's a cost of that, but I can't really define what it is. It's relatively small and not material. It's part of the cost that we have to build. To make something similar in the U.S. in the FCM structure, we can do. In terms of the various identifiers and that we may need from a regulatory standpoint, we've worked incredibly hard to build a standalone system that does that and build out new things. In terms of risk managing, what we have to do, we understand we have the counterparty risk to our buy-side clients, and to basically get our buy-side clients comfortable that we can handle this type of risk, we basically have to have all that stuff available at the legal entity level, and we have to be able to manage that, and we are well on our ways to doing so.
And let me turn briefly to the buy side. Let me tell you my understanding, and please tell me where I might be going wrong. Clearly, if these guys incur operational costs, those are going to find their way out of your pockets because they're going to impose them on you. Putting that aside, operational costs that you would incur separate from whatever you're paying this side, I can't see that there would be, there's risk issues, but I don't see that there are operational costs. Please tell me where I'm going wrong on that.
We actually think that operational costs could decline by entering into this model. Right now we have significant operational costs across our dealers to maintain the custody accounts, to maintain the collateral valuation and margining across the multiple dealers that we have. And we see that narrowing and having a much more consolidated, efficient approach when we do this. So we actually see this as a cost savings. But in any event, we're prepared to bear the cost to provide for the margin protection that our clients need.
I think, apologies that I use car analogies here from a manufacturer here, but it's cheaper to make a car without safety features. It doesn't mean you want it. And so, yes, I agree with what Bill said here exactly. It will, there's less complexity to the LSOC model, to the OTC tri-party. Absolutely. Do we want it? No. I think one of the things that gets lost here is we're focused on cost is we really haven't talked about the benefits. The CCPs, which are going to be bearing these costs, just got a monopoly by law. I mean, if it's a standardized contract, it's required to be traded on the platform, and they're going to get all the business. They didn't have to spend any marketing money for it. They didn't have to do any in-court anything to get it, and they're going to get it. They're going to have some cost, but they just got a windfall. Right now, in our tri-party arrangements, for years we've had dealers pay us, pay for the cost of the tri-party arrangements. We didn't have to pay for anything. And so why should that change now that we're going to go to a cleared model? We should be able to get what we've been able to negotiate in the past. So I think the cost needs to be also focused on losses. We will lose, we'll be exposed to, depending on which model gets adopted, fellow customer risk, investment risk, transit risk, record-keeping risk. We lose netting across products because of clearing. We have to pay initial margin we don't have to pay. We've got lots of costs that we have to bear. Nobody's crying on the T about us. So point is that the cost really shouldn't be the focus. They're getting a windfall to get all this business. They should incur the cost associated with that. We shouldn't lose anything as a result of it.
And I understand your perspective. Let me tell you where I'm coming from. Section 15 of the Commodity Exchange Act requires that the Commission, before it passes a rule, consider, among other things, cost and benefit issues. And so in order for, this is ultimately a part of a rulemaking process. We must consider costs, and we're not allowed to just simply say, well, gosh, they're getting some goodies from Dodd-Frank. So what I'm trying to get on the record here, and what I'm trying to understand is, as in fulfilling my obligation to to the Commission to help the Commission consider costs, we've separated out operational and risk costs, and we're going to do risk costs after the break. I just want to get the issue done with operational costs. Are there any operational costs that if we did LSOC versus, say, the futures model, that would increase for the buy side?
Yes. So let me just, the fact that I have to do things that take me a lot of time today doesn't mean that get ready for everything else won't cost me stuff. In fact, I will have lost all the money that I spent setting up those things, which to provide protections. And you also mentioned that you have to consider benefits. The things that I just mentioned are the benefits that the CCPs are getting as a result of this.
And I want us to consider the benefits, but I'm trying to get an understanding with respect to the costs. So you're saying you would pay more, there would be additional costs that you would incur under the LSOC model that you wouldn't incur under the futures model.
What I'm saying is that the full seg model, which is what we're advocating for, as I think many of the people on this side of the table, that we have sunk money into it, that then that money will get lost as a result if we go to a model other than that. And in addition, we will have to incur other money to get set up technologically for a new paradigm. And so that's cost to us as well. So there's a loss of investment into operational investments we've made already for our tri-party set up, and then there's a cost for us in terms of getting set up for each of the CCPs, each of the FCM's models in terms of how they're going to do it. So yes, there is significant.
That's a cost if we adopt the LSOC model versus a complete legal seg model.
Exactly.
Okay, but my question, and I understand that point, and that is noted. My question is, complete legal seg versus futures. Is there an additional cost to complete legal seg versus futures?
There is no additional cost between LSOC and the futures model.
We don't see incurring, other than the startup cost, the one time, everyone will have to incur to set up, the running costs. We don't see any incremental costs.
And I would agree, no additional operational cost. However, there may be additional credit hedging costs, which we may get to.
Yeah, we're going to get to those right after the break. And so it is now 3:25. I think maybe since we've run over, we'll try and keep it. Can we get back at around very promptly 3:40?